rise. The Court of Appeals, Division 1 is now in session.
Thank you all. Please be seated. We are here for a status conference in our case number CAUB 170128 OSC. Let me, before I kind of talk about what I want us to cover today, first start with appearances. Counsel.
Yes. May it please the Court, my name is Carol Spotty. I'm Assistant Attorney General representing the Department of Economic Security. Seated next to me is my co-counsel, Assistant Attorney General Joanne Talgett. And we also have the client present here today. We have Mr. Henry Darwin. He's Interim Director of ADES, and his Operations Manager, James Hilliard, and ASA Administrator, Marilyn White.
Very well. Thank you. We are here for a status conference. Please be seated. Thank you. And to follow up on a hearing on the 19th of April, 2017, where the same panel, the same three judges, and I think there may be a slight confusion on our website as to who was charged to preside over this, but heard testimony, heard argument from the Department of Economic Security, took under advisement the issue of whether ADES had shown cause for why it should not be held in contempt of an administrative order that this court had issued. I'll call it AO 2017-1, but I may refer to it as the administrative order because we have one that we're focusing on. And we set this status conference kind of as a follow-up to address certain things with the expectation that ADES would make specific filings that they have, and we'll talk about those in a bit. What I wanted us to do today is to address, I think, three things, and let me sort of work backward to start or to conclude with sort of next steps, orders the court may issue. The intermediate step is to hear from ADES and have a conversation about the filings that ADES has and perhaps some questions this court has for ADES about those filings. But in the meantime, and fairly recently, the court has received a couple of filings by specific individuals who've applied or filed applications for appeal. And what I don't know, and let me mention those, and I'll ask if those individuals are here today. Eric Smith. Mr. Smith, good afternoon. And also Kelly Williams. Is Kelly here? Good afternoon, ma'am. What I would propose to do, they have filed what are titled emergency motions. I don't know if ADES has seen those yet.
We have not.
Let me ask Andrew if I have made copies of those emergency motions. They're fairly short, but I understand, just given the recency of those filings, that it is fair that ADES could not respond to them today.
That's correct.
But what I'm inclined to do, and let me hear from counsel, given that those two individuals have come down today, have made those filings, would be to see if they wish to address the court consistent with those motions on topics that I would define. And then if ADES wished to, in the comparatively near future, respond to what they heard after they had an opportunity to review the filings and to hear what the individuals had to say, to proceed along those lines. Given that the individuals are here, have taken time out of their days to come to the court, but made filings very recently with the court. Counsel, do you wish to be heard on that proposed course of action?
As long as we're given time to review them and then respond after we hear what the two claimants have.
That would be my intention. Let's wait and hear what we hear to see how long that might take you, but I'm thinking a couple weeks or something like that if you wish to. Now, so we will proceed along those lines. Let me, and I'll address Mr. Smith and Ms. Williams. If you wish to come forward to this table just here, that would be just fine. And let me wait while you do that because I want to make sure. Yes, sir.
I do apologize to interrupt you, Judge. Mr. Greenberg has been my counsel through this the whole time.
Very well.
At one point, has any anybody reached out to my counselor to let him know any of this circumstance?
Well, sir, let's take it in pieces.
May I approach it?
And you may, and counsel, if you wish to state your name, please, for the record.
Justin Greenberg.
Okay. Come on forward. We can get one additional chair there. And I should mention, too, thank you, that these proceedings are being recorded, as is our custom and practice. The videotape of the recording will be posted to our website and then onto YouTube as time goes along. And the reason why I mention that is, and I've done a bad job to start, but I need each of you when we speak, including me, to make sure you speak in the microphone when you do that. Now, Mr. Smith, I understand you're represented, please be seated. I understand you're represented by counsel, correct?
Yes.
Now, my inclination, given that, would be to direct my questions to him, recognizing he represents your interests, and I'd proceed just like we would in any other court proceeding. Does that sound good to you?
Yes, sir.
Okay.
There are some details.
Well, I'm going to look to your attorney, who you've retained to help you along those lines. And counsel, could you, I didn't write quickly enough, could you tell me your last name again?
Greenberg, Greenberg.
Very well. Now, Ms. Williams, let me ask, because I want to make sure I'm talking to the right person. Can you hear me okay?
I do have a bit of a hearing problem.
Okay. Will you raise your hand if you can't hear what I'm saying?
Okay.
You are here representing yourself, correct?
Correct.
Okay. And that's okay. I just want to make sure I'm speaking to the right person, okay? Now, as I read the motions that you filed and that you have mailed to the ADS, but they hadn't gotten yet.
They stamped in my copy yesterday.
Okay.
Excuse me,
Yes,
Your
ma'am.
Honor, I didn't know that that Mr. Smith was represented. And his emergency motion was filed as a pro per.
Correct.
And also the other one is also filed as a pro per.
Ms. Williams, yes?
So at this time, we'd like to object because Mr. Smith is represented and he could have filed through his attorney.
Very well.
And this is the first that we've heard of Kelly Williams.
Well, it's the first time you've heard of the motion, and I understand that, and that's what I tried to convey. That doesn't surprise me that you hadn't seen that, just given the recency of those filings. Let me hear from Mr. Greenberg. Do you wish to be heard on that objection?
Well, yes, because I did represent him at the initial DES hearing. In fact, we had a full hearing, took full testimony, cross-examination, et cetera. So my name should be on this record. I just haven't received anything, no.
Well, and just so I understand, then one of my colleagues has a question. You currently represent Mr. Smith in this matter?
Yes. Well,
I want to make sure, because that matters.
I represented him in regards to his DES hearing,
Right?
also workers' compensation hearing and OSC hearing.
And we're here for a status conference on an administrative order with respect to UB proceedings. You understand
Yes,
that?
I do. I've read everything. I'm aware of that. Admittedly, he took the go ahead and filed the emergency motion.
And we'll get to that in a little bit, but my question's pretty direct. Do you represent him here today?
Yes.
Okay, thank you.
Well, in that regard, I mean, is there a reason why you wouldn't have filed a notice of appearance? I mean, just so my understanding is that the application for appeal has been considered by our court and has been denied. I mean, so the process is over. We'll get into that more, but the process is over for purposes of his appeal. And I don't think, unless you're telling me something different or going to tell me something different, you haven't filed a notice of appearance on his behalf in the case. That's correct, right?
That's correct. I only would have filed a notice of appearance in the original claim of the DES.
Question.
Yes, counsel.
No, this whole thing just seems a little bit, I feel like we're being ambushed, basically. We haven't received applications, we'd like an opportunity to respond.
Sure.
in writing.
Sure.
And then if the court wants to set a separate oral argument on these issues at a separate time, that would be much more appropriate. But we did not come here prepared to address this today.
I understand that. Let me,
I'd just like to add that DES is the respondent here, and there is no plaintiff.
let me suggest what I would like to address, and perhaps that will help all involved. With respect to these motions, they address, one addresses, I believe Ms. Williams addresses an administrative matter that's currently with DES. But otherwise, they address two things that are important to the court. One, whether Mr. Smith and Ms. Williams received a copy of the administrative order or have a copy of the administrative order. And that is part of what we're here to address. And the other, which is important to the court, was given that their applications for appeal have been resolved by this court and denied, whether those were denied because of any delay caused by ADES. And that's something that the court can address. And my hope would be we could address that issue today to hear about whether these two individuals have a copy of the administrative order now and when they received it. And then if you wish to respond to those issues in due course. That it's very limited.
We know that Mr. Smith has received a copy of the administrative order because he sent a copy of the order with his correspondence to the Attorney General's office.
Okay. And what I would like to do would be to hear from Mr. Smith's counsel and Ms. Williams on those 2 points. Then if you wish to respond today, fair enough. If you wish to respond in writing in due course, fair enough. And then also for the court to address whether any delay in processing the appeal to the court explains the outcome of their appeals, because it doesn't. Fair enough?
Yes, Your Honor.
Okay. Now, what I'm inclined to do, Ms. Williams and Mr. Greenberg, you've heard what two very limited but important, or very narrow but important issues that we can hear from you about today. Mr. Greenberg, your client, I believe, by the filing, has received a copy of the administrative order. Is that your understanding?
Yes.
And is it the question about when that was received or how it was received that creates the issue?
Yes, because I certainly didn't receive it, so yes.
Okay. And you're aware, and this is to Ms. Williams as well, that administrative order is posted on our website, correct? You know that?
I was not aware of that. No.
Okay. It is. And with respect to the motions, by their reference, they specifically reference the administrative order. So that suggests to me that your client and Ms. Williams, you've received a copy of the administrative order. Is that fair?
Certainly.
Ms. Williams, you have a copy of that administrative order?
I'm sorry, when was the order issued?
Well, I'm looking at your letter, and it talks about, I respectfully ask this motion to be entered into evidence and to give testimony regarding Administrative Order 2007-1. That's something you filed with the court. And that suggests to me you're aware of it, because otherwise you wouldn't know how to. Okay. Does that sound about right? And I'm sorry, is that yes or no?
Yes.
Okay. And with respect, the important thing to the court is that you have a copy of that order, and it sounds like you both do. And you have it, and you've made reference to it in your motions, right? Both of the motions, as I see it, raise an important question to the court, given that, as I understand it, by looking at our court's records, your applications for appeal have been denied at this point. They were denied in April last month. Does that sound right, Ms. Williams?
Yes.
Okay. And Mr. Greenberg, does that sound right? Okay. The question that I take away from these motions is, was that ruling, the ruling in your cases, was that on the merits of the application for appeal, or was that caused by any delay by ADS in forwarding the application for appeal to the court?
That's exactly what I'm trying to find out.
Right. And I can tell you the answer is your application for appeal was not ruled on based on the delay that ADS did in sending the file to us. We distribute these to panels of judges, and I can't tell you about the specifics of exactly what caused them to rule one way or the other, but I can tell you that the rulings are on the merits of the application, not based on any delay that the Arizona Department of Economic Security had in forwarding your application for appeal to this court. And it was important to me, given that you're both here, that you heard that from the court. Now, we have concerns about ADES's delay in forwarding things on, and I'll talk about that in a little bit. But the ruling by this court, once the appeals get to this court on your application for appeal, is not affected by that. We look at the merits of the application for appeal. I'm not saying you're happy with the outcome, believe me, but I did want you both to hear that that was based on this court's consideration of the merits of your appeal, not on anything that ADS did or did not do in transferring that file to us. Yes, ma'am.
I have a hard time wrapping my head around how they could have taken the time to review the merits of 140 cases in that time frame.
And help me out, ma'am, 140?
140 cases that they failed to file timely. How they could have taken enough time to review each and every case to deny it on the merits of the case.
Well, let me make sure we understand each other. The applications for appeal come from ADES to this court. Okay? They're processed in our clerk of court's office and then assigned to 3 judge panels. Those judges look at the application, the record, the application for appeal, and decide whether or not they wish to grant the appeal. Those decisions are made on a case-by-case basis. Okay? Now, as far as the specific timing for your case, I don't know the answer to that. But I can tell you this. It is not, the ruling that you received last month is not based on ADS's, failure to send that to this court in a timely fashion. Okay? Now, I think that for the issues for this court for today, that really kind of resolves the 2 issues. And Ms. Williams, I understand you have other issues with ADS on an administrative side that is not before this court right now. And I don't want to get into those given the nature of the issue. But I wanted you all 3, and particularly both, to hear from the court how those cases are processed. Okay? Now, this is a public hearing. You are more than welcome to stay for the entire portion of the hearing. ADS, do you wish to have 2 weeks to respond to the issues raised in those motions, to look through them?
I think you've covered it, Your Honor.
Well, let me do this. We will give you 2 weeks if you wish to file anything in response to those motions after you've had a time to look at them and proceed accordingly. And with that, with respect to the 3 of you here, I'm at this point going to ask you to go behind the bar. You're more than happy to stay for the entire hearing. And if you wish to, I'd encourage you to do that. Mr. Greenberg, your client has indicated he may wish to address the court. Do you want to confer with him before he does that?
I think he's fine. He can address it.
Good.
Your Honor, it says back in November there was 2 cases, 2 appeals submitted to the DES. The one that I originally submitted to them showed this man in my home.
Okay.
Now, the one that shows that you guys denied shows that I was a pro se.
Okay.
Now, I didn't handle that paperwork, nor did I file it pro se. The problem that I have is that I believe that, and yesterday I was called via teleconference by the 2 ladies next to me right here, not contacting my lawyer. They didn't reach out to him in any proper fashion, and were interrogating me under the circumstance, trying to explain the employment process to me.
Let me do this, and I appreciate you raising that issue. Your attorney has told not only this court, but counsel for ADES that he represents you now. And that, let me finish, sir. Let me finish. I can't undo what has happened, sir. But counsel knows that. You know that you will deal with Mr. Greenberg with respect to any claim by Mr. Smith. Is that your understanding?
We were responding to a letter that Mr. Smith signed with his name only and did not have his attorney listed on it, so we really did not know that he was represented until he told us so.
And I understand what you're saying, and I will tell you, Mr. Smith, I did not necessarily tumble to the fact that you were represented by counsel based on your motion, okay? And I try to get that right every time. Now, I know that now.
Just on top of the letterhead.
Well, I see an emergency motion that contains your signature.
Yes, I did my own legwork because I can't afford to pay a lawyer.
And we just found out.
Wait, hold on. You're represented by Mr. Greenberg at this point. Okay, we all know that now. And that means that Mr. Greenberg needs to make filings with the court. And that,
Where is this one filed, Your Honor?
sir, I'm looking at your emergency motion that has your name and a service sheet by you, not your counsel. So just understand why I did what I did, okay? All right, thank you. Let me, with the hope of trying to provide a little more context to follow up on our conversation so far. This court has sort of three aspects of the UB situation that we find ourselves in right now. One is the status conference and the order to show cause given the administrative order that this court issued and that is currently publicly available on our website. And that's what we're going to talk about in just a little bit. The second is a consolidated number of UB cases handled by a different panel, not any of the three of us, where the work on that panel remains pending. No final decisions have been made. And then the third are the individual cases that this court is asked to resolve. We've heard from two of the individual applicants earlier today. But I want to try to set forth those three different aspects of what this court is doing so that we can focus on why we're here. We're not here other than on what we've heard already, given that we had two people come down to the court on any specific case. We're not here certainly on the consolidated case, which is pending before another panel. We are here, however, as a follow-up to our show cause hearing on the 19th of April, where this court heard testimony under oath, heard argument, took the issue of contempt under advisement, set this status conference to allow ADES to do some additional things, to make some additional filings, and for us to have a continued conversation. Now, in advance of this hearing on that point, the court has received 4 filings, and let me look to counsel to make sure we're on the right page with that. We've received, and let me see if I can get these dates right, on the 16th of May, notice to the court regarding its revised process flow outline for applications for appeal. We've received in a document dated the 5th of May, a notice to the court regarding sample weekly audit report, and then of that same date, I believe, yes, a notice to the court regarding inventories. And those were 2 documents or reports back from ADES that we addressed the concepts reflected in those when we were here at the hearing, on the 19th of April. And then the 4th filing that we have for today's hearing is a notice of the court dated the 5th of May 2007 that corrects some what I recall as typographical sort of errors in an inventory provided to the court previously that we had talked about at the hearing on the 19th. What I would like to do is to hear from ADES on any additional information or discussion overview of those filings that they wish to provide. We had also talked about when we were here last whether ADES knew of any additional more formal referrals or otherwise with respect to a former employee. And then we may have specific questions on these individual filings as we go along. But I wanted to hear from counsel for ADES before we headed down that path.
Thank you, Your Honor. Since the OSC hearing in April, the Department has been processing the appeal applications within the timelines set forth in Administrative Order 2017-01. The department has filed case inventories for March and April, which show that each application for appeal has been submitted within the court's timelines, and also a sample audit report. The department's monthly case inventories and its weekly internal audits have proved effective in capturing all the appeal applications that have been filed. The department revised its process flow outline to ensure that the attorneys of record for the parties receive proper notice, and that pending appeal applications are not subject to collection efforts. The department's internal affairs unit is conducting an investigation regarding Ms. Dominguez and will refer the matter to AGO for further action if appropriate. And what the department is proposing in lieu of any monetary sanctions is just continued oversight by this court of the department's appeal application processing through monthly inventory and audit reports for 6 months.
Counsel, let me ask, anything else is introductory remarks, and then I know, at least I have a few questions on your filings. Nothing to add at this point.
Okay.
No, I'm asking.
No,
Okay.
nothing else to add at this point.
And forgive me, it's a habit I learned as a trial judge that mm-hms and head nods don't make a particularly good record, so forgive me on that. But with respect to the notice regarding revised process flow outline, do I understand correctly that the changes to that are the highlighted language? There are 4 highlights in that filing?
Yes, Your Honor.
And then it looks to me on page 2, and I'm sorry I have a black and white copy, not a color copy, that there are 2 different colored highlights. Are those intended to have meaning, or is it simply a function of the software?
Oh, if you had the color copy, the yellow would relate to making sure that the party's representative is recorded properly.
Bullet 5, if you will, number 5? Okay.
5, yes. And also number 5 on page 2.
Romanette 5, is that?
Yes. So those are all intended to make sure that when the department is transmitting the appeal application, that it has the proper parties' representatives, if any, on there. Okay. And then directly below it, and what would appear as green on our copy, is just that.
And just so I'm with you, page 2, it's Romanette 8.
8, yes. That is to ensure that while an application for appeal is pending, that no collection efforts go forth during that time period. And that under 7 on page 3, 7A, that addresses the same topic.
And are these changes things that are put in place as of this moment?
Yes, Your Honor.
Okay. And in fact, I see a date of the 12th of May at the top of the first page of that. Is that when they were put in place, or was it before that?
Yes, May 12th.
Okay. Let me look if my colleagues have any questions on that specific document. Okay. Let's then turn to, let me see if we have any questions on the notice with respect to the inventory.
Ms. Salvetti, I'd just like to ask it at the risk of hopefully not confusing everyone about which exhibit we're talking about, but what was known as Exhibit A, the inventory list, but then it was DES filed updated on May 5th, an updated inventory list. Do you have it in front of you?
Yes,
okay.
Yes, I do.
I wanted to ask you about one of the headings, because it's something I didn't catch last time. I know we talked about a couple of corrections, but I'm looking at the heading delivered to court. And most of them, especially on the last few pages, make perfect sense to me that they're delivered to the court somewhere between January and March, somewhere between January and March of 17 of this year. But there's a number of them that say 2013, 2014, and if that's the case, I'm wondering why they're on the inventory list.
Oh, this is, I'm wondering if we're talking about the same list, because the department submitted its inventories for March 2017 and for April 2017. This was submitted,
And I see that document as well, but this is the fourth document that I had mentioned. And if
So
you...
did I jump ahead? Sorry.
No, which is
Sorry.
fine. We jumped over the
Sorry.
second and the third. This is the fourth. It was filed
I apologize.
on the
I didn't
5th of
know
May, and it talks about pointing out two errors respecting the dates.
This is
Are
the
you-
list of the 277 cases.
okay, that's what we're calling the original list, and Judge Downey had found two
Correct.
errors in it.
Yes.
Yes.
But we're talking about a document that you filed on the 5th of May, after,
But that's the one that corrects the two errors that I
Right.
pointed out at the last hearing, I think.
and I think Judge Brown has some other questions about that same document.
Yeah.
Are we working on the same document?
Okay, so this one would be,
It's actually on both of them. I mean, his
Yeah,
question.
yeah, my
it doesn't
question
really
relates to
matter.
either one. It doesn't matter, the original document or the
Oh.
May 5th document,
okay.
because that didn't change. This is the date of delivered to court. Doesn't seem to make sense. I'm wondering what that date, that means when the boxes were physically dropped off here at the court. Is
Yes,
that
delivered to
correct?
court. Yes, they're sent, may I check with Ms. White?
Of
on
course.
that?
Sure,
Okay,
absolutely.
Ms. White, so that's when those are actually delivered to the court, physically delivered to the court. Well, I think, if I'm understanding Your Honor correctly, it's just the date that we physically, the department physically dropped off the application to the Court of Appeals.
Counsel, do you wish to approach, I want to make sure we're working on the same filing, and it's important.
See, and I think the confusion was, we were operating at the last hearing under the assumption that the 277 cases were in the, what did you call them, stale category.
Yes.
But it looks like maybe some of these were actually, if you look at case numbers 3, or case number 3, for example, that shows that the appeal was filed in December of 13 and delivered to our court in March of 14. And so that's where we started looking at it again to see maybe this is a different universe of cases than we originally thought. We thought these were all delayed appeals that were in this document. But you see how some of them were
Yeah,
filed with
'cause-
us in 14.
Because that would suggest it wasn't really a delayed appeal. I mean, it was
a little bit
3
delayed, but-
months, but it wasn't.
And if you need a minute to
And Ms. White may
confer
want
with
to
your
look at it,
client,
because,
right?
yeah, if you look at number 4, or number 3, number 10, a number of them were delivered to us in either 2013 or 2014, according to this, so, yeah, sure.
Of course.
Your Honors, I apologize for the confusion. Those were cases that were identified as unknown in whereabouts, and when we searched our records, we originally thought they had not been filed, but they had been filed back on those dates. There were a few that were showing up as not received by the court that we showed we had sent to the court, and that's why it has those old dates, not current dates. There were a few that just made the list, the original 144 on the court's list, that had in fact been transmitted, but the records had not, for some reason, caught up to each other.
Okay. So it sounds like maybe there needs to be some reconciliation between our staff and this list. I mean, just at some point, I'm not saying it needs to happen today, but I mean, we just want to know, because one of the problems we have, well, we're still working on processing all the cases, haven't been able to quite get there yet.
Sure.
So it's processing them into our case management system. But, so that's something we will undertake, and we'll take a look at that to see if we can get these to see where they match up and where they don't.
Yeah.
So,
There was a situation as well where there were, I don't know how many, 20 or so cases that we showed delivered to the court that the court did not have record of receiving at the time and told us they did not have them, so we reproduced the records and submitted them again. So we do know that you guys got them eventually, I'm sorry. We know that you did get them eventually, but our original records showed different dates. And then we found that they had been sent by our courier somewhere else, not material to this, but the dates that these, in this delivered to the court column are the dates that we show in our case tracking system as having sent a file to you. But until you know, my staff person, who is now the clerk for the appeals board, is working very closely with two different people in your clerk's office to make sure that when we say we sent it, they say, you say you got it, that we actually are talking about the same thing at the same time.
Thank you. Appreciate
So
that.
they're trying to get that reconciliation of all the cases so that your website and our spreadsheet will reflect the same things all the time.
Thank you.
May I approve?
Yes, you may. Thank you, Counsel. Let's turn then next to the filings, the notices, and they were the second and the third document that I had mentioned that I believe they were both filed or dated the 5th of May with respect to weekly audit report and inventories. Now, if I recall correctly from our hearing on the 19th of April, we had asked ADS to look into what kind of periodic reports it could provide to the court for a period of time so that we would have collectively some comfort that the situation that brought us here would not happen again. And are these the samples, if you will, that ADS has been able to pull together and provide?
Yes, Your Honor.
Okay. And I read both these notices as indicating an ability for, and the reference, I think, is to ASA, but to, correct, the Appellate Services Administration of ADS, to provide both those forms of report on a monthly basis as ordered by the court for a period of time. Is that fair?
Yes, Your Honor.
That is something that, and we've conferred before we took the bench, that has great interest to the court, and something we had talked about when we were here last. What sort of, are those closed out monthly? I mean, if the court were to order those to be filed going forward, would that be something on the 5th of the month, the next business day, or on the first day of the month? Help me out in terms of how you're capturing that data.
The audits are performed weekly, so if the court wished to have monthly reports, then we would just submit the 4 weekly audits for the month, and then the case inventories would be prepared just month by month.
And then with respect to the mechanics, because I think we will order that those be provided for a period of time on a monthly basis, what mechanically, how long, is it a day, is it 2, is it 3, for ADS to prepare those after the close of the month? And if
I'll
you
have
wish to confer, of course.
Yes. The next business day.
Okay.
We want to give them a little more leeway than that. 3 days. The 5th of the month.
Yes, ma'am.
As my co-counsel has just reminded me, that it usually takes us a couple days to prepare a notice of appeal, because the Solicitor General's office reviews everything that we file, that we are intending to file with this court.
And that's fair, and that's why I'm asking the question, because I think we're inclined to set a specific date on the month, and then to be fairly unsympathetic if a report isn't made by that date.
The 5th? Okay, the 5th of the month.
5th of the month? Okay.
That's fair.
Let me look to my panel mates and see if there are additional items you wish to address before issuing orders for today. Okay. Here's what we will do. ADS will have 2 weeks to respond to the motions that they have now received. With respect to the audit reports and inventories, and I'll call those monthly, even though I understand your audit reports are done weekly, we will order that ADS file those no later than the 5th of the month, or if the 5th is not a business day, the next business day following that. for the prior month with this court in this case number until further order of the court. Can those filings, and I would like those for this month, which would require those to be due in the first part of June, and so we'll direct that that's when it starts. With respect to the issue of contempt that we addressed at the prior hearing, and the court did take that matter under advisement, that matter remains under advisement. We have noted in the consolidated case that counsel, I believe 2 days ago, has filed some recommendations with that consolidated panel that may implicate what this panel does, but we will wait for that, given that that is pending before the consolidated panel, not this panel, and the response time has not expired on that front. And at this time, pending further order of the court in the OSC for the Administrative Order 2017-1, we will set no further hearings at this time. Counsel, before we adjourn, any questions for the court? I want to make sure that ADS understands with precision what we are requiring.
Yes, sir. I don't have any questions unless co-counsel or the client. No. Okay.
All right.
We've understood.
Very well. Anything else for the good of the order today?
That's all. Thank you, Your Honor.
Thank you. We stand adjourned.